Probably calls the issue was we're going to review the status of the sale of the Sprinter Keystone Camper and the status of the $3,500 payment from Mr. Phillips to Miss Mayville. The parties have met with Ms. Barr for the front of the court this morning, who has provided the court following recommendation. The defense shall contact the dealership within 48 hours to sell the 2004 camper. And the parties will appear back for his court to review this matter on January 30th at 3 p.m. What about the $3,500 payment?
Your Honor, I have not worked. I've been back in the hospital again. I just got out last.
You got to borrow it. I'm telling you, got to borrow it. You agreed pursuant to terms of judgment divorce, Ms. Barr. We need to address this issue as well. It's still an outstanding issue. Have you paid any of it, Mr. Phillips?
No, I haven't, because I was going to borrow it from my boss, but my boss let me go because he feels it's too dangerous to, at this point, for me to be working for him because of the health issues.
Okay. Well,
and my son's paying my bills right now to help me out.
Okay. And are you unemployed right now?
Yes, I am unemployed.
You need to apply for Social Security, Mr. Phillips.
I have.
Do you have a hearing date?
Everything. I'm waiting on the attorneys to contact me. All the paperwork is done.
Well, you contact the attorneys. You call the attorneys every week, Mr. Phillips. Tell them that you have a court that's pushing you to comply with this order, Mr. Phillips. So you call the lawyer every week to say to get him to move on this matter. You can't sit on this matter for months and months.
Okay.
And don't forget, you're paying 5% interest on this $3,500.
Yeah, I know.
So what have you done to sell the Keystone camper? Have you just put a sign in the window, or what have you done?
We've listed it. There's, I've talked to people. You know, hey, I'm offering it for the $3,500. It's valued at $6,000. Nobody's interested. I mean, it's just the wrong time of the year to be trying to sell one.
Okay. So, do you have any objection to this recommendation that the court order you to contact the dealership to sell it?
No, I have no objection at all.
Okay. But you got to sell it for a minimum of $3,500. Is there any debt on that? First of all, is there any debt on the camper?
No, there's no debt on it.
Okay.
The reason that I took 3 parts out of it, and that was the electronics for the furnace, the refrigerator, and the hot water tank to make work in this one, because this one was struck by lightning. And it's approximately about $400 worth of parts to replace it, and it goes back to the value of $6,000. And the only reason I took this one was a friend of mine said, "Hey, it's a year-round unit. Take it. I don't need it on my yard." I mean, she's acting like I spend a lot of money on a camper. I didn't. I can tell you the person I got it from. He would put it, "Hey, this is what we're doing."
Reviewing the judgment of divorce, Mr. Phillips, you agreed that because you're awarded Sprinter camper, you agreed to pay your wife $3,100 for her interest in that camper. So you owe $3,100 plus the $3,500.
I paid the $3,100. I paid the camper off to her.
Oh, is that correct,
yes.
Ms. Mayville? Okay.
Yes, it is.
So all you got to do is sell for a minimum of $3,500 so you can satisfy your remaining obligation to Ms. Mayville.
Correct.
All right. So obviously there's a couple of dealers in southeastern Michigan, correct, Mr. Phillips?
Yes.
Okay. So driving around those couple of dealers and see the best they can offer you for it.
Okay. The question I have for you, Judge, what if they come back and say we'll only give you $1,000 for it? I mean, what do I do?
You're not going to give it away. I mean, it's up to you, sir. But again, you still got to come up with that difference. So I wouldn't give it away. If in fact you believe it's worth $6,000, no, I wouldn't give it away. I'm not ordering you to sell it to whatever they'll pay for it. But continue to list it and get some
at this
from
point,
dealers.
Your Honor, I've listed it at the $3,500, the amount of money that I owe her. And nobody's even contacted me on it. I've listed it for what I owe her, and it's worth more than that. But nobody's just buying them right now.
Where'd you list it at? Is it online listing?
I've listed it on Facebook. I've listed it on Craigslist. I've talked to people in the campground that I'm staying at. They know it's up for sale. It's just nobody. I mean, it's just the wrong time of the year, Your Honor. I don't mean no disrespect to the court or anybody. I know that I owe her the money. I was in the hospital for a week last week because of renal failure, and the left coronary artery is now blocked. So I have two main arteries that are blocked in the heart. So my boss let me go at work because he feels it's just too dangerous for me to drive truck right now. And it's not like I'm trying. You know, I know that I owe the money. I know that I do. And Your Honor, there's two things I wanted to bring to your attention. In the original, when we were going through the divorce, I was supposed to get the appliances. We showed up that day to get them. She was not there like she promised the court. So I just gave them to her because it wasn't worth the fight. And there's a gun that's reported stolen. I can't get it back. So the Monroe County Sheriff contacted the store to where I bought the gun, has the serial number to the gun, and has been reported stolen. So there's property that she took that I can't get back, and I have not brought to the attention of the court because of the health issues. I really don't. I just want to, you know, I don't want to drag this through. But there are other issues here, and I've kept quiet, Your Honor. But this is, you know, it's not like I'm not trying. I mean, she left me because of the reason of heart failure. I want to deal with it.
All right, so we'll modify, the court will modify the language of Ms. Barr's recommendation that you shall contact, how many dealerships can you contact? More than one?
The dealership because I feared that they were just going to say, here, we'll give you 500 or 1,000 for it, but I will contact them or today.
Okay.
I will contact them.
Okay. I'm going to suggest you contact at least two dealerships and secure offers. Get a written offer from them.
Okay.
I'm not going to order that you sell to them or whatever they're willing to offer you, but you come back with written offers and continue your listing. Maybe there's another entity that you can list it with. Maybe there's an RVcamper.com or something. I don't know. I'm not a camper.
I will.
But maybe something other than Facebook.
I will start working on that today.
Obviously, you're going to do much better in the open market than you will with a dealer. So I'm not going to order you to just to give it away to a dealer. You got to come up. Obviously, you want to come up with at least just $3,500.
Yeah, I mean, I'm offering for half the value of what it is right now.
All right, so Ms. Smith, you acknowledge you've already received $3,100 for your interest in the camper. Is that correct?
I did get the $3,100 for the camper.
Okay. All right. So the only issue is the receipt and collection of $3,500 plus interest.
Yeah, correct.
I mean, Your Honor, I'm willing to take the camper to where she wants and give her the title.
No, I don't want it. You done stripped it and lived in it, and I don't know.
All right. No. So she's not interested, so that's not an issue. So perhaps if Barry can change language at defense shall solicit offers from dealers.
Okay.
Well, it's up to the camper, and that could you also note in your recommendations, Barry, that for the court's future reference that the plaintiff acknowledges receipt of the $3,100 for interest in the camper, but defendant still owes her $3,500 plus interest. So I know that's what the issue is when we come back. So we'll review this matter on January 30th at 3 p.m. Mr. Phillips and Ms. Mayville. And Mr. Phillips secured a couple of written offers from these dealers. So they provide a copy of those to Ms. Mayville as well as to the court. Send those, drop them off to the courthouse, or mail them into the court the week before.
Okay.
Okay.
So get a couple written offers, and continue your efforts to list it in the open market. And maybe there's some additional sites you can use rather than just Facebook. And Facebook is sort of limited. So we're just going to order that you secure offers from dealers. We won't set a 24-hour time frame. Just secured offers from dealers. Again, there's enough incentive for you, Mr. Phillips, to move this matter because you're paying interest. Each day you're paying additional interest on $3,500. So we're going to view the status of the $3,500 obligation when we come back on January 30th at 3 p.m. And we'll note that $3,100 was already received by Miss Mayville for her interest in that camper. Ms. Barr, do you have any questions?
Are you removing the 48-hour window?
Yes.
Okay,
Yes.
yes.
Yeah, we'll give them some time. Being the holidays and so forth, it may be difficult to find full staff at some of these dealers. So get around. There's at least I think there's got to be at least 3 different dealers in southeastern Michigan, Mr. Phillips. So
Burrito, I can
drive it
contact
out.
all.
Take a day driving around to different dealerships.
Okay.
Come take a look at it. All right, Ms. Mayville, do you have any questions?
No, sir.
Okay, we'll see everyone back. Hopefully, we'll have some resolution. And obviously, Ms. Mayville, if you know somebody that wants it, send them on to Mr. Phillips. It's
No, they don't
obviously
want
great steal. They can buy it a $6,000 camper for $3,500.
Yeah, I paid $7,000 and he only gave me $3,100. So, yeah, it's okay.
All right. We'll see everyone on January 30th at 3 p.m.
Okay, thank you.
All right, you can zoom out. You're welcome.
Bye-bye.
On page 1, Robert Moss versus Tiffany Goodell.
For the record, this matter is before the court for the purpose of reviewing DNA test results. This hearing is being conducted via Zoom. Present is Attorney Christine Hills representing the plaintiff Robert Moss. Mr. Moss is present. In addition, defendant Tiffany Budell is also present. Good morning, everyone.
Morning, Your Honor.
The court is in receipt of a DNA test report dated December 14th, 2023, which indicates there's a significant probability of paternity on the part of the plaintiff, alleged biological father, Robert Moss. 99.9999% probability of paternity. Ms. Hills, I think your office provided the court with a copy of this DNA test report. Is that correct?
Yes, it is, Your Honor.
All right, Ms. Budell, we just lost your video. Are you still present, Ms. Budell?
I am here, Your Honor. I'm sorry. I'm just having an issue with the computer.
Okay, as long as we can hear you, that's fine. Ms. Budell, did you receive a copy of this DNA test report?
No, but I know he is the father.
Ms. Budell, did you receive a copy of this DNA test report?
No, Your Honor.
Okay. Ms. Hills, can you, someone needs to mail a copy to Ms. Budell?
Yes, Your Honor. I'm sorry. I believed she would have received a copy from the testing agency. That's my fault.
Ms. Budell, Ms. Hills will mail you a copy. Do you want to see a copy of this report before we proceed any further?
No, I know he's her. No, he's the father. No, I don't need that.
Okay. All right. So you acknowledge then that courts in receipt of a written report from DNA Diagnostics dated December 14, 23, which indicates that there's a significant probability of paternity on the part of Robert Moss as being the biological father of the minor child Shiloh. And you acknowledge that, correct?
Yes, Your Honor.
And I do recall you previously suggested or acknowledged that he was a biological father, but we now have certainty with respect to that. Ms. Hills, you recall, did the court take testimony for both parties?
No, I don't believe so, Your Honor. I believe that there was some testimony taken when Ms. Zagorski covered for me. I recall that from her notes.
All right, well, it wouldn't hurt to just briefly go through this again. Mr. Moss, Ms. Budell, can you both please raise your right hand to be sworn? Do you both solemnly swear affirm that the testimony about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, Ms. Hills can begin with Mr. Moss, please, confirming his acknowledgement to receive his DNA test report and his testimony regarding paternity, please.
Yes, Your Honor. Recently come into possession of DNA testing results from the DDC testing agency. Is that correct?
Yes.
And you were determined to be the father of Shiloh and a greater than 99.999% probability. Is that correct?
Yes.
And you in fact were tested by the lab affiliated with DDC?
Yes.
All right. And do you acknowledge that those paternity DNA test results are accurate?
Yes.
And are you asking, and is that, were you involved in a sexual relationship with Ms. Budell at the time this child would have been conceived?
Yes.
All right. And are you asking the court to determine you legally to be the father of Shiloh?
Yes.
All right. And do you have any questions about that or concerns about that as you sit here today?
No.
All right. Does the court require any other facts to
No,
be elicited?
No, thank you, Ms. Hills. Ms. Budell, can you please state your name and current address for the record, please?
66.
Thank you. Ms. Budell, did you hear the testimony of Robert Moss this morning?
Yes, Your Honor.
Is his testimony true and accurate to the best of your knowledge?
Yes, he is her father.
Okay, and once again, under oath, you acknowledge that Mr. Moss is the biological father of your child, Shiloh. Is that correct?
Yes, Your Honor.
All right, thank you. Ms. Hills, do you have any questions, Ms. Budell?
I do not. Thank you.
All right, based on the DNA test report, as well as testimony parties, the court specifically finds and determines that the plaintiff, Robert Moss, is in fact the biological father of my own child, Shiloh Moss. Date of birth, the court does not recall offhand. Is Mr. Moss on the birth certificate of the child?
No, he did not sign it.
Okay, all right. All right, so the parties have conferred with Ms. Anderson in front of the court this morning regarding the paternity. Court having determined paternity, the next step, of course, is to address parenting time, child support, and so forth. The court has received a fine recommendation from Ms. Anderson this morning. Is that the parties shall share joint legal of the minor child with the plaintiff, defendant mother having physical custody of the minor child, Shiloh. Father shall have parenting time as follows: every Sunday from 12 noon to 4 p.m. and every Wednesday from 5 to 7 p.m. And the parties can agree to adjust those dates and times if needed. It's further recommended that the issue of child support be referred to the friendly court for formal investigation recommendation, with each party having 21 days in which to object to the friendly court recommendation. If there is no timely objection, the recommendation in front of the court shall become an order of the court. The effective date of that child support shall be January 1st, 2024. And neither party shall make any disparaging remarks about the other parent in front of the minor child. And finally, the parties shall appear before this court to review parenting time as well as child support on February 13th, 2024 at 10:30 a.m. via Zoom. That's the recommendation. Ms. Hills, is this recommendation agreeable with Mr. Moss this morning?
Your Honor, with the understanding that the custody provisions are temporary and without prejudice, yes, it is.
So the recommendation does make it clear that they are temporary without prejudice, joint legal physical to mom. Ms. Budell, do you understand the recommendation this morning?
Yes, I do, Your Honor.
Do you have any objection to the court adopting this recommendation?
I would just like for the child support to be retroactive since birth, Your Honor. That's
Well, if you wanted that, you should have petitioned for paternity and child support back then. Ms. Budell, so the court cannot go back to the date of birth because it's whoever petitioned, and Mr. Moss was one that petitioned for a finding of parentage and paternity, so it will be effective. Whether it's the only issue is whether it's effective commences December 1st or January 1st. January 1st should be because we've just finally determined paternity today. So the court believes that the child support should be effective. You could have taken the affirmative steps back then, Ms. Budell, you didn't. So the child support will, whatever amount is ordered, will be effective January 1st, 2024. With respect to this parenting time, does Mr. Moss have a car seat for the child?
Your Honor, it's my understanding that he's going to be exercising it at Ms. Budell's home or a mutually agreed upon location. She's going to be there to assist him in warming up to the child. He hasn't seen her very frequently over the last few months. Is that your understanding, Mr. Moss?
Yes.
All right, well, that makes sense. And actually, I missed part of the recommendation. The recommendation for parenting time was every Sunday 12 to 4, every Wednesday 5 to 7, and every Friday 4 to 6. So I missed that third day of the week. So a couple hours, 3 days a week. And Ms. Budell, you're agreeable that Mr. Moss can come to your home to develop a relationship with Shiloh?
well, I said we would meet somewhere, like the Funland or Fantastic or dinner, or that's what we do now, and it works great. We don't always have to meet at my home.
Well,
I have
the
5
Funland in
children.
Monroe, I know, but the Funland in Monroe, how old is Shiloh?
That's where we go. She's 15 months.
Okay. Well,
Yeah.
The court took the grandchildren out to the Funland. It's just a bunch of bouncy houses, not really a place for a parent to just spend time with the child. And sometimes the child's more that age, more comfortable in a home, especially your home.
Yeah, so they do have a toddler section there. They do have a section that he plays with her in, and they have sofas and they sit and watch whatever. We don't go there often. It's just an example of things that we can do besides sit at my house.
Okay. So you're not opposed to even the exercise period time at the home of Mr. Moss, correct?
We will not go to his house.
Okay. Well, do
My
we
daughter
need to
don't hang
solidify
out
where
at
this is
dope
going to occur
houses.
then?
She don't hang out at dope houses, Your Honor. No, sir. No, Your Honor. My daughter does not go. No, Your Honor. Ooh.
Wow, can we do something about this?
Yeah, we will. We will. You want to be
She could just keep
investigated?
sitting there talking about like this to me.
You want to be investigated? Because we can take it there, Mr. Moss.
Oh yeah, we need to check your house out too, because you need to get people looking in your house with all your covers and stuff, not covered for children.
All right.
How about that?
It sounds like if you can agree. Obviously, Mr. Bedell, you chose him to be the father of your child, so you need to live with that. You're gonna deal with him as the father of your daughter's.
That's great.
Father of your daughter until she attains age of 18. This court's going to direct these matters.
Yes, Your Honor. My job as a mother is to keep Shiloh.
It'll take any place agreeable between the parties other than the Mr. Moss's home. Is that what you're asking, Ms. Bedell?
That's all I'm asking, Your Honor.
What if we can't agree then?
That's someone's got to help me protect Shiloh. I'm shaking, Your Honor. Like, we don't have that lifestyle. When I lived at that house, I shut everything down.
What if you cannot agree? Does the court need to order where it's going to occur? Can you agree?
If Shiloh was to get sent to one of his houses, that's not safe for Shiloh.
Well, you're going to be present.
No, we don't want to be a part of that lifestyle, Your Honor. Let's just avoid it.
Will this be hold on. Will this be unsupervised parenting time then? You'll simply drop them off at the Funland and you'll leave?
Never.
Okay. So that's why I'm asking this. We need to clarify this is supervised parenting time. Ms. Sills, you understand be supervised?
That mother would be present during his parenting time. And for now, while we disagree with everything that she said about his alleged lifestyle and the lack of safety of his home, and we'll be prepared to address those issues at the next hearing with photos and whatever else we need to show that his home is appropriate for Shiloh. We do agree that the parenting time be exercised other than at his home for the next few weeks, and that mom be present.
Right, thank you. So we'll clarify the recommendation, Ms. Bedell and Mr. Moss, that the parenting time will occur at such locations that may be mutually agreeable, and it should be supervised in nature by Ms. Bedell. So you can agree upon whether it's a restaurant, McDonald's Playland, the Funland of Monroe. I don't know of any other appropriate places, or I guess the home with Ms. Bedell, if that's satisfactory, but it's got to be a location that's mutually satisfactory. And we can discuss other locations when we come back on February 13th to discuss parenting time. Let's see how things go.
Okay.
All right. So are you comfortable with that, Ms. Bedell? Between now and February 13th, it'll be at locations to be mutually agreeable and supervised by you. Understood? Ms. Bedell, the court cannot hear you.
She's not muted. I don't know why
You need to turn up your volume. We cannot hear you. So, Ms. Anderson, you can modify your recommendation, Kate, the parenting time, Michelle, be supervised at the location be mutually agreeable, please.
Yes, Your Honor.
That makes sense. Thank you.
She's gone.
Okay, Ms. Bedell is gone. Hopefully she'll be reconnecting in one moment. I'm sorry to keep you waiting.
Your Honor, I also updated for it to be supervised by mom for parenting time.
Thank you.
Is the court satisfied with the court's form order as the order affiliation, or would you like me to do a more formal order?
I'll leave it to you, Ms. Ells. The court's comfortable with the recommended order prepared by Ms. Anderson. I think it's pretty thorough. When you receive that, if you think something else needs to be added, you can do that. If you need to. I do believe the recommendation as to be amended was satisfactory to Ms. Udell. So if
she comes back in, should we just tell her that it was adopted?
Well, if you cannot wait, Ms. Ells, then we'll let her know that. Oh, she's trying to come back in again.
One more time. I'm fine, Your Honor. I just wanted you to be prepared for the beeping noise in a few minutes.
Okay. And Ms. Anderson, are you sending the court an updated revised recommendation?
Yes, Your Honor. I don't know why it's not working or showing up, but I'm trying to pass it through, but I can't find it. So I'll have to contact somebody here to find it for me.
So you can't, Ms. Anderson, just simply add another sentence to your prior recommendation. You have to redo it all. Is that how you?
So I have it up. I just add to it, but I have to re-upload it to OnBase.
I see. Okay. I don't mean to create additional work.
No problem at all.
So if Ms. Sills, if you need to sign out, we don't want any burnt toast this morning. If you need to sign out, we'll just confirm with Ms. Udell that we've added that additional language about supervised at a location mutually agreeable, and hopefully she and Mr. Moss can agree where it's going to be. Mr. Moss, you want to make it work. So
yeah, I want to make it work 100%.
The location, we can review this, maybe come back in February, but if it's got to be the Funland of Monroe, Playland at McDonald's, maybe it can be creative about some other locations. Maybe the Toledo Zoo.
Yeah, whatever. I just want to see my daughter. I really do.
So maybe be creative with some other suggestions, and even if you got to buy her lunch or something, buy her coffee, it might be fun going in a location other than Funland of Monroe.
Right, I agree.
All right, so court will wait on online here, Ms. Sills, and we'll let Ms. Budell know that you, Ms. Moss, cannot wait any longer, and we'll add that additional language, I think, which will satisfy her, and we'll come back and review this matter in February.
All right, I appreciate that, Your Honor, and if there are any issues, Mr. Moss, please let me know right away.
All right, thank you.
You're welcome. Talk to you soon. Bye.
All right, bye-bye.
Thanks, Judge. Happy New Year, everybody.
For the record, this matter is before the court on the defendant father's objection to a referee recommend order that denied his request for parenting time on account of his affair to appear that he appeared late. This hearing is being conducted via Zoom. Present is Eric Sims, defendant father, as well as plaintiff mother Kendall and Lewis Toll. Good morning, everyone.
Good morning.
Ms. Toll, Attorney Zagorski did contact the court this morning advising that she was ill this morning and had hoped to appear on your behalf. I understand you don't want to do anything until she's here, but the reality is we need to move this matter forward. The court's going to be off for a period of time in January. I don't want to sit on this for a month. Excuse me.
Judge, may I interject?
The court is proposing that dad have supervised parenting time at Family Counseling Shelter Services, which is supervised by a master's level therapist. It's safe for the child, and at least it starts that process. There's a waiting list, so it's not going to happen overnight. So that's what the court was contemplating. Ms. Toll, you're opposed to that?
I am, because there's other things that we would like to discuss with you before anything moves forward. It's very important that we bring that to your attention.
Okay, go ahead.
I don't want to do that without my lawyer, Your Honor.
Well, she's ill, and we can't sit on this. And let me ask Mr. Sims. Mr. Sims, did you complete the probationary terms? And this all started when you assaulted your girlfriend, Alyssa Kendi, in front of your child. Was there a criminal conviction for that?
There wasn't. Excuse me, it wasn't in front of my child.
Okay, well, that's what was alleged. Are you on probation for a assault conviction?
No, I'm not on probation for that matter.
What happened to the charge?
I was found guilty. You did 7 months in jail.
Okay. Do you still have a relationship with this Alyssa Kennedy?
Absolutely not.
Okay. Did you ever complete an anger management counseling program? That'd be important.
No, I wasn't ordered to do so.
Well, The court thinks that if you want to establish a relationship with your son, then maybe you should enroll in an anger management counseling program that can assist you in controlling your emotions and anger.
So I'm in a separate program for that.
What do you mean you're a separate program for that? You said you're not on probation.
No, I'm not in.
Completed such a program. I'm suggesting you should.
I'm not in an anger management program. I'm in an MRT program.
Okay. What is MRT?
Moral recognizance therapy.
Are you on probation to some court in order to do that?
Yeah, I'm on felony probation.
Oh, all right. That's what I'm trying to get at. So you, for the software, let's kind of, you were just given straight jail time. What are you on probation for? What type of criminal conviction?
Assault with a dangerous weapon and R&O.
Okay, and as part of that, is that here in Monroe County?
Sure is.
Okay, assault with a dangerous weapon, and you're on probation. When did your probationary term expire?
In August
of 2024.
Oh.
And you are right now taking a class called MRT.
Yep.
And what does that stand for again?
Moral recognizance therapy.
Does that class touch upon anger management issues?
I mean, it touched down on everything morally.
So how often does that class, do you attend those sessions? Once a week?
So I attend twice a month. I will be completed with that class, I would say, before the end of January.
Okay. Well, I think it's important that what you want to do is you want to provide Ms. Toll as well as a court written verification you completed that program successfully. I think that's important. Obviously, your child has a right to have a relationship with you, and the court wants to move forward with that. Ms. Toll wants to talk with her attorney. Obviously, but that would help considerably if you can provide documentation that you've completed that program, what it entails, a brief description, you've successfully completed that program. That is very important. Ms. Toll, are you opposed to dad even having phone contact with your 11-year-old? FaceTime?
Right now, yes.
Okay. And why is that?
Because he would be confused, and he's doing really well right now. And the last thing I want is for it to affect his school and everything that he is doing right now.
At some point in time, he's going to have a relationship with his dad. You understand that? You accept that? I mean, it's not like, well, we're going to wait till he turns 18 to have a relationship with his dad. That's not going to happen.
I do hear you, but there are many factors in this situation.
Okay. Yeah, is your son currently
Mr. Sims,
in counseling?
What was that?
Is your son engaged in counseling?
He was. He has been multiple times over the years, and there's a lot of stuff he has seen and heard that really affected him. Okay.
I know there's an incident that occurred in September of 2022. That's what would prompt this court to suspend dad's parenting time with your 11-year-old son. So the counselor does not believe he needs any more counseling then, correct?
He is not right now. No.
Okay. The whole purpose of counseling is to work through the issues he's got with his dad and what he has seen.
Right. But
so in fact, if you believe your son's not ready to reestablish a relationship with his dad, then you need to get him back into counseling.
I can get him back into counseling.
Okay. That's critical. So you're opposed to dad having any contact with your son right now, with his son, I should say.
Our son, yes, I am. I'm sorry.
Right. All right, so I'm going to put it over a couple of weeks, but again, I'm let you know we're going to move in that direction. Ms. Toll, we're not going to. There's no reason why we cannot move forward with family counseling shelter services, but we will adjourn this to a couple of weeks. Mr. Lewis, we're going to I'm sorry, Mr. Sims going to give her a chance to have her attorney present. How about the week of either the 17th, 23rd, 24th?
17th is, I could do 3:15. 17th.
Okay.
Next week's a bit more.
Miss, okay. What do you see?
I have on the 24th, I have 1:30.
Ms. Sanders, we'll adjourn this matter to the Wednesday, January 24th at 1:30.
Yes, Your Honor.
So, Ms. Toll, you need to notify Ms. Zagorski. She's got to make it work. It's a Wednesday, January 24th at 1:30. Recommendation, Ms. Andrus, that Ms. Toll wishes to have her attorney present, so the matter is adjourned to January 24th, 1:30 via Zoom. Will that work with your schedule, Mr. Sims?
Yep.
All right. So make a note. It'll be a Zoom hearing, Ms. Toll. It's your obligation to reach out to Ms. Sikorsky. She did not file this objection. You did, so the copy mailed to you and to Mr. Sims. You need to forward that to her. Let her office know as soon as possible. January 24th at 1:30, and we will address it at that time. Mr. Sims, the court again would suggest that make a note as soon as you complete that program, that MRT program. You want to provide written documentation. Basically what the brief description of what that involved and entailed, as well as your successful completion of that program and how long it was. So I'm sure you get a standard letter to that effect. That will help. I don't know if you'll have that by January 24th, but as soon as you're done with that program, you want to get that letter.
Make sure I do.
Okay, if you can get it before the 24th, that would be great. And then fully move forward. And Ms. Toll, if you still are opposed to your son having, because it's your son and Mr. Sims' son having contact with dad, you need to get back into counseling, because that's what the court's he has a right to that relationship with his dad. So if you believe he's got some issues, you need to get him to counseling to work through those issues. All right, so that will, you both mailed a copy of the recommendation. We'll adjourn this matter January 24th, 1:30. For the record, this matter is before the court and adjourned. The noble hearing on the defense objections to recommend order that denied his motion to reinstate parenting time for the reason that Mr. Sims had failed to appear for that referee hearing. The matter was adjourned to today's date as the plaintiff's mother, Ms. Stoll, wished to recontact Attorney Maria Zagorski, who's present with us here this afternoon. Good afternoon, Ms. Zagorski.
Good afternoon, Your Honor.
So Ms. Zagorski is present on behalf of the plaintiff, Mother Kendall and Toll. Ms. Toll is present, as is the defendant, Eric Sims. Parties have conferred with Ms. Anderson in front of the court. Ms. Anderson is present for the final recommendation that the referee recommend order be adopted, which denies Mr. Sims parenting time. Is that correct, Ms. Zagorski?
Yes.
And the court's aware of the background facts and circumstances. What about therapeutic or supervised parenting time with family counseling shelter services?
Yes, I know that's an option, Judge, but as I've set forth in my response in my brief, Mr. Sims has not shown that he is compliant with any of the prior orders of the court, that he's compliant with his probation, that he's getting mental health treatment. He hasn't provided any evidence that it would serve the child's best interest to be reintroduced to him. As I've set forth in my response, every year there's an issue, and this child is doing well. He's doing well in school. He's doing well with his extracurriculars. And before we risk his emotional well-being again, it seems that Mr. Sims would have to carry his burden of proof. Mr. Sims misrepresented himself when he was before you the last time and said that the minor child wasn't present during the last incident. The minor child was in fact present, and I've attached the text that verify that from Mr. Sims' own mother, and which state that this child should not have any contact with Mr. Sims. There's simply no reason to disturb this child's current situation until Mr. Sims can show that he doesn't pose any risk to the child's emotional or psychological well-being. Every single year we have a problem. Mr. Sims has assaulted his parents multiple times, at least 2 women in front of the child. My client has been a victim of his violence. Law enforcement has been a victim of his violence. And so it seems to me that we're doing what we've always done without Mr. Sims providing any verification to the court that it would be good for this child. And so I am asking that until he comply with this court's previous orders regarding showing documentation of compliance with his physician's treatment plans, compliance with probation, that he's taking his medications, that he give us some reason to reintroduce this child into his life, that his requested relief be denied.
Thank you, Ms. Gorski. Mr. Sims, Ms. Gorski does have a good point. First of all, you're currently still on probation. Are you in compliance with your probation?
Absolutely.
Okay. What the court's really want is some documentation that you are actively engaging in active mental health treatment.
So we discussed that the last time I seen you, and you had asked if I was in any anger management program, and I told you that I was court ordered to take a moral recognition therapy class, and I completed that on the 17th of this month, and I was on house arrest for the first 6 months of me being out of jail, and I completed that without any issues. I've been compliant, taking all my psych meds since the first day of jail when I myself requested them. I have a blood draw this coming week to check my medicine levels, see if they need to be adjusted at all. I've done everything asked me by probation, including completing the MRT and taking all my medicine as prescribed by my physicians in and out of jail. And for the record, my son's never physically witnessed me ever commit any act of violence. The day that Miss Toll's lawyer just mentioned, Caleb was on a different floor of the house, and I don't even believe that he even heard the dispute, but there's no physical way, unless he can see through the floor, that he's seen anything occur that day.
Well, you were arrested, correct?
Not that day.
Okay. Okay, well, again, we need to, do you still live with this Alyssa Kennedy?
Absolutely not.
All right. Okay, well, Mr. Sims, I do recall you talking about a program, and I do not familiar with that, moral recognition therapy. I'm not sure what that is, but we need, according to documentation, explain what that is and that you are in compliance, and some documentation that you are in, you're taking the prescribed medications, and that this MRT or whatever it is, that's a form of mental health treatment. We need some documentation rather than just your verbal statements.
Yeah, so I showed that documentation to Emily with a friend of the court earlier, and I was unaware that I had to bring physical documentation into the front of the court or the courthouse in general. Otherwise, I would have been more prepared for this. I would have got a letter from my probation officer, who I believe thinks pretty highly of me. I've been doing pretty well for myself. With the exception of this winter, I haven't gotten a job since I got out. I'm running my own business. I mean, I would have completely came in here prepared with proof of what I've been doing. So I apologize for that, but there's no denying that I, in fact, have bipolar disorder. It's been a pretty terrible roller coaster ride thus far, and every time that I've ever been arrested was a direct result of me not being on medicine. I was unaware that I had bipolar disorder until diagnosed in 2018 when I was found not guilty by reason of insanity. And I'm just trying to put a better foot forward every day and make my mental health a priority, as I didn't in the past. I put work over everything else, and that's what wound me up in jail again, because I was off my meds for over a year, I think, before I went to jail this past time. And I didn't think it was as important as it actually is. So that's where we're at.
All right, Ms. Gorst, have you seen any of this documentation?
He held up a letter today that appeared to be from Community Mental Health, but I was unable to read its content. I have absolutely no knowledge that he's compliant with his prescribed medication or anything else. And I appreciate Mr. Sims' statement that he didn't know he needed to provide this, but I would respectfully assert that this court has ordered it repeatedly, as set forth in my brief.
All right, here's what the court's going to do: is the court's going to adjourn this matter rather than adopting it. We'll adjourn this for 30 or 45 days. Mr. Sims, provide Mr. Gorski and the court directly copies of as much information as possible. A letter from your probation officer saying that you're doing, you're in compliance. I don't know how often you see a therapist. Do you see a therapist with this MRT program?
Yeah, usually once or twice a month. But since I graduated from the MRT program, and that person that, I was meeting with is being transferred to a different position, I'm gonna seek out my own private therapist, because that program's done. So the order that I've been bound to fulfill is completed. I want to seek private therapy someplace else. So.
Okay, that would be wise, and you can talk to that therapist about your desire to maintain and redevelop a relationship with your son. But so I don't know what the date of this. I guess the final MRT report, which explains the program and all your compliance and successful completion. Do you have such a letter? Is that what you provided to Ms. Andrus?
I mean, the only letter that I got, I don't know if you'll even be able to read it. I can read it to you.
No, I'd rather you provide it. See if you get an updated letter, something that says you complete the program and describes the program. The court is not familiar with this MRT program. Does the letter describe what it's all about?
No, I mean, I'll read it to you. It's only 2 sentences. It just says, "My name is Joel McCrae, LMSW, case manager at Monroe Community Mental Health Authority and the Jail Diversion Department. I attest that Eric Sims completed MRT," and then his signature. So, I mean, it doesn't really describe what it is or what it entails.
Yeah, and I don't know how long you engage in that, how many sessions. They need more information about that.
That's been going on since I got out of jail.
Okay, so see if you can get some further information from Community Health about what that program is about, and also how often you saw the therapist, or what did the successful completion of the program entail? Well, the court thinks we need that first and foremost, and obviously, yes, I think it's a great idea to engage in continued counseling. Who's monitoring your drug testing? Probation?
No, the doctor that prescribes my psych meds.
Okay, so maybe a letter from your doctor that you are testing the fact that you are taking all prescribed medications and that you are tested every other week or once a month or whatever.
Well, so the only way to prove that is usually with the medicine that I'm on, you do a blood draw once a year typically, and I had a blood draw like I want to say between 2 weeks to a month before I was released from jail. But I'm going to go and have another blood draw done next week. So, I mean, that's the only way to prove that I'm physically taking the medicine.
Okay. So after you get that blood draw, a couple weeks after that blood draw, get a letter from your doctor attesting to those things.
Okay.
This is what you're prescribed, and he has verified you're taking those prescribed medications due to the following blood tests. So as much documentation as you can get would behoove you, Mr. Sims. So right now, are you involved in any counseling? Did you complete an anger management counseling program or just this MRT?
No, so like we discussed the last time, I didn't do any anger management. I did this because this is what I was ordered to do, and this is more thorough than anger management because it addresses your direct cognitive thought process. But as far as therapy, that pretty well ended when this was completed, which is why I'm seeking out my own personal therapy.
Okay. Court believes that's a good idea to get your own individual therapy and perhaps get a letter from that therapist. So find out what the agency, maybe your probation officer can recommend an agency, and you can make sure your insurance covers that service. But at this point in time, according to Mr. Gorski, we need some documentation that you, in fact, are in compliance with everything, and that it's appropriate for you to reestablish a relationship with your son. Ms. Gorski, if you have any documentation or any evidence that suggests that the minor child saw or witnessed this assault, you say there was a text message.
Yes, Mr. Sims' mother, I attached it to my response. She indicated, we asked Caleb how he was doing several times after the fight. He kept telling us fine. That is the reason we didn't say anything. We believed him. We keep Caleb away from Eric always, et cetera, et cetera.
It's still not clear whether or not the child observed this incident. Oh, I know there was prior assaultive incidents. Is there any evidence that the child was a witness to prior assaultive incidences?
The child never
witnessed. The grandparents?
Yes, he was present when Mr. Sims put a cigarette out on his girlfriend's eye. The Department of Health and Human Services substantiated that in a report that was dated December 14, 2016. Has acted out inappropriately on more than one occasion, committing domestic violence against former long-term partner and currently against his own parents. And Michelle Sims with son, Caleb Sims present, and that was substantiated by CPS.
Right, goes back to 2016.
That was
sometimes past. Mr. Sims seems to acknowledge that he has a bipolar issue and that he needs medication. So hopefully he is turning the corner to recognize that his past poor conduct was caused by that condition, and hopefully he's addressing that. perhaps at some point in time, maybe the front of the court can talk with Caleb to see what his, if he's got any concern about supervised parenting time, or the court was reluctant to have the front of the court involved. Maybe Ms. Toll sometime can get a sense whether or not Caleb would like to see his dad in a supervised, protected environment. So that's something you can talk there about, Ms. Gorski. But at this point in time, the court's going to adjourn this matter to the first week of March. So Mr. Sims can get together further documentation. We have either March 5th or March 6th. Are you available, Ms. Zagorski?
Unfortunately, Your Honor, both those days I will be in Washington, DC at a conference.
Okay.
I could do the week before or the week after.
Maybe the week, last week of February.
I have Tuesday, February 27th at 9:30.
How about February 27th?
At 9:30, that's fine. Yep.
All right. Mr. Sims, will that work with you?
Yeah, I can make it work. What time?
9:30. Ms. Toll, does that work with your schedule?
Yes.
Okay. So Mr. Sims, we want this to be productive. Can you get together all this documentation within the next, you got basically 30 days, and you get this to us in advance to Ms. Zagorski and the front of the court and to this court. You can get 3 copies of everything, one for the court. You can drop it off of the Braunlich window, the 4th floor, one for the front of the court, and then the one for Ms. Zagorski. As much documentation, the more the better. Certainly you want something from community mental health, explain what this MRT program is about, what that entailed. Ideally, something from your probation officer that you're in full compliance. And thirdly, a letter from perhaps your new counselor. You're gonna engage in continued counseling with your new counselor, and enter your doctor that you're taking all prescribed medications, and it's being verified. So we'll send out a notice to adjourn this matter to February 27th at 9:30. Anything further, Ms. Zagorski?
No, thank you, Your Honor.
Right. Anything further, Mr. Sims?
No, that's I just want to clarify something real quick.
Okay, go ahead.
So I want to make sure I'm not underprepared the next time I come. So you'd like a letter from my doctor verifying meds in my system after the blood draw and compliance. A letter from my stating my progress in compliance with probation since release. A letter from my therapist describing what MRT is and what it entails, as well as my progress therapy-wise. Then I'm assuming you're going to want a letter from my new therapist and my progress.
Yes.
I meet with them any amount of time between now and then. I don't know what the new person's schedule is going to be like. And then who all did you say this needs to be delivered to?
To the court, Judge Braunlich, Ms. Zagorski, and the front of the court.
Okay. Sounds good. I appreciate it.
Okay, we'll see you then. We'll send out notice February 27th, 9:30.
Thank you, Judge.
Thank you. Everybody got a Christmas gift for her son. I think so.
Oh, yeah.
So Christy taking Vinny's off school, where the boys are off, so she down to Fred Park mall for a movie to see there was a shooting in the food court. What's a 15-year-old doing with a loaded handgun in the food court area?
That is awful.
But the article mentioned that, but didn't say how would a 15-year-old have possession of a loaded handgun.
Right, he shot himself accidentally.
Yeah.
With a 15-year-old girl.
But why is he?
And then they caught him.
But why is he? How did he get out? They should prosecute those parents. What's he doing with a loaded handgun?
Unbelievable. They've been having problems with gangs down in that area for years.
Yeah.
Because we.
They have. Red Blade said they have an age restriction out for you to be accompanied by an adult if you're at least 17 to see a movie. So we're taking down the movie this morning, and I said, "Oh, maybe lunch and food there." I'm thinking maybe it's not a good place to have lunch. Isn't it terrible?
I know, it's awful. I don't like going there. I don't go there by myself. I know. I always have Alan with me if we have to go. Yeah. I won't go there by myself.
Terrible.
It is. It's like, well, where are you safe? You know, that's a good question.
For the record, this matter is before the court on the defendant father's objections to recommended order of parenting time. This hearing is being conducted via Zoom. Present is the defendant father, Travis Camilleri, as well as plaintiff mother, Karen Camilleri, Parties have conferred with Ms. Brower from the front of the court this morning. Ms. Brower has provided the following recommendation: that the recommended order be rescinded and canceled. Further recommended that the front of the court shall initiate an investigation recommendation regarding parenting time. Both parties shall have 21 days in which to object before it becomes an order of the court. Plaintiff's phone interview shall be January 11th, 2024 at 9 a.m. Defendant's father's phone interview shall be January 11th, 2024 at 9 a.m. Both parties shall contact Catherine Scott in front of the court at a phone number referenced in this recommended order at the time of their interview. So Ms. Scott will confer with both of you and will prepare a written recommendation regarding custody and parenting time. And on a temporary basis, without prejudice, mother shall have parenting time on a 2-week schedule. Week 1, mom shall have parenting time Mondays after school, or 8 a.m. if no school, till Thursdays to school, Thursday mornings, or 5 p.m. if no school. And on week 2, mother shall have parenting time Monday after school to Friday to school. Week 1 will commence January 1st, 2024. So essentially, Dad would have the weekends, and week 1 he'd have Fridays as well as the weekends. That's the recommendation this morning. It's a temporary recommendation. Mr. Camilleri, do you understand the recommendation?
Yes.
Do you have any objection to the court adopting this recommendation on a temporary basis?
I still wanted to keep the schedule the same way as it was, but that's a recommendation.
Okay. Are you opposed to this recommendation on a temporary basis?
Yes, but
all right. And parenting time, as it was basically you had mom had the children Monday after school. This is pretty much similar to what I see in the pleadings. Mom had the children Monday after school until Thursday.
Yes.
And then Dad, you had the children Thursday after school you basically had long weekends with the children.
Yes.
Okay. And why do you think that should continue?
That's the way that the schedule has been, but also when the kids are in school, Friday morning, since her schedule, she cannot be there to put the kids on the school bus. She'd have to have somebody else, so that's why I always took Thursday.
Okay.
So the kids can be with the parents at all times.
The children get on the school bus at your home, or do you take them to school?
I drive them to school.
Okay. All right, Ms. Camilleri, what's your position on this recommendation?
I agree with the recommendation.
Okay, how do you get the children to school on Fridays?
My mother will be home. She's staying home to get them onto the school bus, and then she'll be heading to work.
Okay, so the children will never be late?
No.
And do you live with your mother?
I do live with my mother.
Okay. All right, Mr. Camilleri. I mean, the primary thing is the kids get to school on time. If in fact Ms. Camilleri could not assure his court to get the children to school on time, then I would agree. We need to relook at this.
Okay.
And Ms. Camilleri, you work every weekend, is that correct?
I do.
Okay, you testified to the referee that you work every other weekend.
No, I had told her that I worked every weekend and that I wanted to not have to work every weekend, but it seemed to work better that I could have my children for long stretches.
All right. Obviously, the referee misunderstood that because in the recommendation, she indicated you testified that you worked every other weekend. Well, let's give us a try. The court's going to adopt Ms. Barr's recommendation on a temporary basis until we should have Ms. Scott's recommendation in early February. You both have interviews on January 11th. She should have that interview. Do you want to schedule another review date, Ms. Brower? Do you think as perhaps we should? Or I guess let's wait, see if somebody files objection. All right, so the recommendation which your court will adopt is that presented by Ms. Brower this morning. And you'll both get a copy of the written recommendation. And if you disagree with it, file a written objection, it'll come right before this court, and the court will make a final decision. And obviously, but the two of you as parents should know what's best. You want continuity, consistency for the children. Make sure they get to school on time. If in fact they don't want to be late for school, and if in fact it makes more sense for them to get the bus at dad's house, they'd like to take the bus, for example, and you should both be able to recognize that. You know what's better for the children. You far better off than this court does. So I think two of you should continue to discuss as parents. You've been doing pretty good lately. And the home has not yet been sold, correct, Mr. Campbell? You're still in the marital home, still on the market?
No, the marital home has been sold.
Oh, it has been. All right. So, Mom, you live in Carlton. Dad, where do you live?
Romulus.
Okay. Obviously, that changes things with the kids getting to school. I mean, the kids take a school bus from Romulus to airport?
No, I drive them to school.
Oh, drive them.
I've always drove even from the marital home, I had to drive them to school. So this whole time I drive them to school, and we have special routines in the morning.
Well, the court has confidence in Ms. Brower. She's discussed with you at length and made this recommendation. So again, we're going to have Ms. Scott conduct a formal investigation recommendation. You'll both be interviewed by her on the phone January 11th, 2 o'clock for Mom, 9 a.m. for Dad. And until then, commencing January 1st, which is next week, Mom will have a 2-week schedule. Week 1, Mom will have after school on Monday, or 8 a.m. if no school, to Thursday after, or to school Thursday mornings, or 5 p.m. if no school. Then week 2, Mom will have Monday after school to Friday to school. So that's essentially all the weekends. And if we need to make this change, we'll make that change in February. So let's give it a try.
I just asked for one thing.
Go ahead.
With the time, since Monday they do not have school, and it's New Year's Day, and the kids will be up a little bit later, is it possible to change the drop-off time from 8 a.m. to 10 a.m.? Just at one time.
Okay, it seems reasonable. Ms. Camilleri?
I really would like them in the morning. I mean, I asked for them.
8 a.m. is early. The kids probably want to sleep a little bit, right?
Yeah, I understand that. But
so we'll make for the one exception. It's not an unreasonable request. So we'll just add a sentence, Ms. Brower, that on January 1st, the exchange time shall occur at 10 a.m.
Okay.
Thank you.
For that one day. All right. Doesn't like work. Let the kids sleep in a little bit.
Thank you.
All right. So we'll make that modification, and we'll welcome all the copy. And again, when you get the written recommendation, if you agree with it, then it'll become an order of the court. If you object to it, then you got to file a written objection. Really follow with the clerk of the court and send a copy to the other party, and it'll come be scheduled back for this court. All right, we'll give it a try. And again, the two of you as parents talk about it. Children are they both in 10 and 6? They're not yet in high school.
No, and I'm not looking forward to that.
Okay.
They already grow up so fast.
Okay, well, we will see you if necessary sometime in February if there's an objection, but try to work through it together. All right, that will conclude this, Mayor. Thank you, Ms. Brower. You both will have to copy this recommendation. You can both zoom out.